Well, good morning. I'm Jogendra Rana. The topic for the discussion today is take it or leave it attitude of insurance companies. Take it or leave it attitude of insurance companies. Observing that the take it or leave it attitude of the insurance companies are unwarranted, the District Consumer and Dispute Redressal Commission directed an insurance firm to pay rupees 15,000 as compensation to a city resident for denying the claim without valid reasons. The Commission also directed to reimburse an amount of rupees 54,228 spent on treatment to the complainant along with an interest of 9% per annum. The Commission said it is generally seen that the insurance companies are only interested in earning premiums and find ways and means to decline claims. In this complaint, the insured Sanjeev Rana, a resident of Sector 38, stated that he obtained a health insurance policy and on April 10, 2024, visited a private hospital in Mohali for consultation after feeling uneasiness. So as there was no relief, he again approached the hospital and was advised admission. So at the time of discharge, the hospital filed a claim with the insurance company, but it was rejected. As per bills, the complainant had to pay rupees 54,228 for his medical treatment from his own pocket. But despite notices, the insurance company did not put an appearance before the Commission, and accordingly they proceeded against ex parte wide order dated October 30, 2024. But the Commission said there was no merit on the grounds of the company for denying the claim that the need of the hospitalization was not established based on the lab reports. The Commission said it is for the treating doctor hospital to see if his hospitalization is needed for the patient or not. After hearing their arguments, the Commission held the company guilty of deficiency in services and directed it to reimburse the amount and pay compensation to the complainant for the harassment and litigation expenses. And in a significant ruling, recently the Chhattisgarh High Court has upheld the liability of United India Insurance Company Limited to pay compensation in a motor accident claim, despite the insurer's contention that the insurance policy was void due to a check dishonour. Now the court also enhanced the compensation granted to the claimant from rupees 2.75 lakh to rupees 6 lakhs. The case revolves around the tragic death of a 12-year-old boy, Deepak, who was fatally injured on April 21, 2017, when a tipper truck wearing registration number CG04JC2459 hit his bicycle near Rajkumar Kirana shop. So the vehicle was being driven by Lokesh and owned by Ramji Sahu. The boy succumbed to injuries during treatment. Now the parents of the deceased Puran Lal and Chitralekha Bai had filed a claim petition before the Motor Accident Claim Tribunal, Baloda Bazar, under Section 166 of Motor Vehicle Act 1988. So the tribunal had awarded compensation of rupees 2.75 lakh with an interest of 9% per annum against the insurance company. So dissatisfied with the compensation amount, the claimant filed MAC number 1380 of 2018 seeking an enhancement of the award. Meanwhile, United India Insurance Company filed MAC number 1746 of 2018 seeking to set aside the award and absolve itself from the liability, arguing that the insurance policy had been cancelled due to non-payment of the premium. So the primary issue before the Chhattisgarh High Court was whether the insurance company could be absolved from the liability on the ground that the insurance policy was cancelled due to dishonour of the premium. whether the compensation awarded to the claimant was adequate or required enhancement. So the bench, presided over by Justice Naresh Kumar Chandravanshi, delivered a common judgment for both appeals. On the issue of insurance policy cancellation, it said the insurance company contended that the vehicle owner, Ramji Sahu, had initially issued a check for the insurance premium covering the period from April 5, 2017 to April 4, 2018. But the check was dishonored on April 18, 2017 due to insufficient funds. As a result, the policy was cancelled and a fresh policy was issued only on April 26, 2017. So, which was after the accident. However, the court found that while the bank had informed the insurance company about the dishonored check on April 11, 2017, the insurer did not promptly notify the vehicle owner. Instead, the company sent the notice much later on May 4, 2017, after the accident had already taken place. But the court also had the insurance company issued an immediate notice. The owner could have deposited the balance amount. The delay in sending intimation deprived the owner of this opportunity. It further noted that the check was dishonored due to a minor shortfall of Rs 988, which could not be considered an act of bad faith on the part of the vehicle owner. Given these facts, the court held that the insurance company remained liable and dismissed MAC number 1746 of 2018 filed by the insurer. And on the question of enhancement of compensation, the court also reviewed the compensation amount awarded by MACT. It noted that the tribunal had based its calculation on the Kishan Gopal vs. Lala and others 2014, once SCC 244, where the Supreme Court had assessed a notional income of Rs 30,000 per annum for a disease minor and applied a multiplier of 15 to compute the compensation. However, since the accident in the Kishan Gopal case occurred in 1992, the court recognized that inflation and the declining value of money warranted an increase in compensation. So, referring to Supreme Court's decision in Kushmi Devi versus Mohammad Qasim and others, the court enhanced the compensation amount from Rs 2.75 lakh to Rs 6 lakhs, citing the financial value of rupee has significantly depreciated over the years, and compensations should be revised accordingly to meet present economic realities. So the appeal filed by the United India Insurance Company was dismissed, and the insurer was held liable to pay the compensation. The claimant's appeal was allowed, enhancing the compensation from Rs 2.75 lakh to Rs 6 lakh with an interest of 7%. The insurance company was directed to deposit the enhanced amount within 2 months before the MACT. The enhanced compensation would be kept in a fixed deposit for 3 years in a nationalized bank for the benefit of the claimants. Insurance claims can be rejected for a number of reasons, including incomplete documentation, incorrect information, or late payments. So, providing false or misleading information about the age, income, or occupation can lead to claim rejection. If you don't disclose pre-existing medical conditions when you're buying insurance, your claim may be rejected. If you don't pay premiums on time, your policy may be terminated and your claim can be denied. Or violating the terms and conditions of your policy can lead to claim rejection. For example, using a personal car for commercial purposes. Most insurance policies have a time frame for filing claims. If you delay filing a claim, it may be rejected. So, claim rejection can be due to procedural errors, while claim repudiation is a final decision made after the insurer review the claim. If your claim is rejected due to a procedural error, you may be able to resubmit it after correcting the issue. after considering the issue. And see, the India's insurance companies rejected 11% of health claims and had 6% pending as of March 2024, according to the report. Now, health policy claims worth rupees 26,000 crore were disallowed and appreciated by insurers in the year ending March 2024, marking a 19.10% increase from the year before. So the rejection amount was rupees 21,861 crore in the year ending March 2023, according to the IRD report. So a claim is rejected or disallowed when an insurance company refuses to process it due to specific issues with its validity. This means the insurer has not yet evaluated the claim for coverage but has rejected it outright due to errors or discrepancies in the policyholder's documentation, terms, or procedures. On the other hand, claim repudiation occurs when the insurer denies the claim after a review, so determining that it does not meet the terms and conditions of the policy. The report highlighted that the overall insurance penetration in India declined for the second consecutive year in 23-24, dropping to 3.7%. This marks a decrease from 4% in 22-23 and 4.2% in 21-22 during the pandemic. So IRDAI's report commented on the performance of insurers in claim settlement ratio, the percentage of number of claims an insurance company settles within a specified period, that is called claim ratio. The public sector insurers had a settlement ratio of 103.38% in 23-24, indicating that they paid out more than they collected in premiums. In contrast, private insurers maintained a ratio of 88.71%, while standalone health insurance insurers struggled with a low ratio of only 64.71%. This disparity suggests that customers may face varied experiences depending on their choice of insurers. Life insurance companies paid rupees 48,512 crore in death claims for the year ending March 2024, an increase from rupees 46,380 crore in the previous year. So rupees 28,868 crore was paid for individual policies and rupees 19,644 crore for group policies. So to mitigate the risk of claim rejection, policyholders are encouraged to take proactive steps: thorough documentation, understand policy terms, seek clarification if uncertain about any aspect of your policy. So, the rejection by the insurance company is not deliberate. But the question is, once a claim is rejected, it also affects the image of the insurance company. Because the claim rejection and claim repudiation in health insurance are different things. Understanding why your health insurance claim might be denied is crucial for effective coverage. Many people confuse claim rejection and claim repudiation. Claim rejection occurs when the insurer denies your claim due to errors or missing information before evaluating it. But claim repudiation happens after a thorough review, where the insurer decides that the claim does not meet the policy terms. Now the question is, why a claim is rejected? Claim rejection occurs when your insurance company refuses to process a claim for specific reasons related to its validity. This means the insurer has not yet assessed the claim for coverage but has outrightly rejected it due to errors or discrepancies in the policyholder's documentation, terms, or procedures. The claim rejection occurs when your insurance company refuses to process a claim due to specific issues with its validity. Unlike claim repudiation, which happens after a detailed review, the claim rejection occurs due to errors or discrepancies in the policyholder's documentation or procedures before the claim is assessed for coverage. There could be incomplete or incorrect documentation, non-disclosure of pre-existing conditions. There could be policy lapses also, like violation of policy terms, incorrect procedure followed. So these things can be corrected at the right time, but still the claim rejection is increasing, reputation is increasing every year because of the attitude of certain insurers, and that attitude is take it or leave it. But that condition should not be there. Courts are very strict about this attitude. Thank you very much.